I wish you a good 2-day strike.
After 1 year, members of the Bar Association of Armenia have launched a new protest strike. The lawyers will not take part in court hearings and other procedures during this strike, which is taking place on June 10th and 11th. On June 11th, 2012, more than 500 lawyers staged a 1-day strike protesting against the Court of Cassation, which they say bears the primary responsibility for the existing uncertainty in the judicial system, its unpredictability and the application of the law. Today, the demands of the lawyers are the same, but fewer lawyers are taking part in the strike.
The preparation phase of the strike showed that we are seeing injustice in the actions of the Court of Cassation, and there is an urgent need to struggle against these injustices. Lawyers are forming their opinion about the Court of Cassation based on the results of the cases of many people that went through all 3 stages of the judicial system.
According to lawyer Alumian, if a citizen loses in the first and second stages of the judicial process, it doesn't affect him as negatively as when his appeal is rejected by the Court of Cassation without an explanation.
The Court of Cassation must provide an explanation for rejecting an appeal, but in real practice, usually the reason given for such decisions is very generalized and does not explain adequately the reasons for the rejection and justifications included in the appeals. Moreover, the decisions to accept appeal is not explained by the Court of Cassation. Usually, substantive judicial acts do not include explanation at all. Why, on what basis the appeal was proceeded? What is the justification?
According to the striking lawyers, although the Republic of Armenia Court of Cassation is designed to provide the uniform application of law and should contribute to the development of law, in fact it continues to deviate from that path. The standards and procedure of appeals remain in the dark, while the acceptance or rejection defies logical analysis.
The unexplained decisions of the proceedings by the Court of Cassation and also their failure to explain the decision to reject the proceedings of the appeals are undermining the legal, convincing, and genuine legal action status of the decisions of the Court of Cassation. They are also damaging the predictability of the defense of the rights of individuals at the Court of Cassation, and they lead to the risk of corruption and finally to double standards and discriminatory decisions.
The Department of Judges considers the lawyers' repeat strike premature.
Regarding the strike, we have a lot of questions, because the strike that took place in 2012 was solved through discussions organized between the highest bodies of the state, and as a result of those discussions, they came to the conclusion that the uncertainties existing in law enforcement practice, which are reported by lawyers, can be resolved as far as possible through filling the gaps within the law, through giving a new momentum to the judicial reforms, and through the expected new draft law. I think they should wait to see what the outcome of the legislative judicial reform package will be. What kind of new provisions will be settled in the new draft law, and only after this should they take such a step. Moreover, joining an initiative brought by only 100 lawyers when there are 2,000 practicing lawyers does not really correspond to the concept of the illegitimacy of the Court of Cassation.
To predict what impact the strike will have and what steps, if any, the Court of Cassation will take in response.